someone could buy my book to fine print and they could send it out to 100 different people and nobody's ever going to pay me for it. That's copyright infringement.
This is Ron Pramshafer, and welcome to Publishing Basics Radio, where weekly we try to help you navigate the self-publishing minefield. Mark, let's talk a little bit about copyrights. You're a copyright attorney, right? Correct? Okay, what is a copyright?
Well, a copyright protects any kind of expression put in any kind of a fixed format. So if you write something on a napkin, it's copyrighted the minute you put it on the napkin. If you type up a screenplay on your computer, the minute you type it onto the screen, there's a copyright. The difference between what's called a common law copyright, which is what that is, and a federal registered copyright is the registration with the U.S. Copyright Office.
Okay, technically you're copyrighted as soon as you write it. But what's the difference between writing it on the napkin and filing it down in Washington?
Well, the biggest difference is you really don't have much protection when you do what's called the common law copyright. By registering it with the Copyright Office, number one, it allows you to bring a copyright suit in federal court. If you're not registered with the Copyright Office, and let's say you take my book to fine print and you start selling it on your own and I go to sue you and I haven't registered with the Copyright Office, I can't sue you in federal court until I register. So that's the first very important advantage. The second one is there's a lot of statutory damages and awards that I get when I'm registered with the Copyright Office. For instance, I get all my costs and attorney's fees, where if I'm not registered, there's no way I could ever get that in a regular copyright suit. Also, the damages, where let's say you start selling the fine print and you don't sell very much of it, but if your conduct is so egregious, I can go and ask a court to award me up to $30,000 per infringing act. So those are probably the three main reasons to get the federal protection.
Okay. All right, so let me give you a little scenario here. I just finished my manuscript, right? I sent a copy of it by email to a friend of mine. Next thing you know, I see my book being advertised like on the internet. 3 weeks later, I see, my book is like a storyline on Law and Order. What can I do?
Well, if, let's say you didn't file a copyright with the Copyright Office, if that's the case, you could still sue those people for infringement, but the only thing you would ever be able to collect is whatever the actual damages are, which may be somewhat hard to quantify. And of course, you'd have to prove the chain of title.
Okay, how about I read around about poor man's copyright or whatever, where you mail the manuscript to yourself or something. Does that work?
The poor man's copyright was probably a good idea maybe 70 years ago.
Okay.
When you don't have the kind of sophisticated technology you have today, because all that really proves is that you stuck something in an envelope and sent it to yourself. Today, I could doctor up an envelope, I could unseal it, I could seal it back up, I could make it look like I sent it 10 years ago, I could do anything. So to go through that effort and do that to yourself,
you might as well do it the right way.
I mean, filing a copyright is not a very expensive process. So to do it that way, you would probably spend, if you had to go to court, you would spend more in court to prove that the envelope was never unsealed, and you'd have to get some kind of expert who could look at how the envelope was sealed. I mean, it would be ridiculous.
Mm-hmm. Now you were mentioning 70, it'd be good 70 years ago maybe. Remind me, how long does a copyright last?
Well, copyright lasts for the life of the author plus 70 years.
Okay, and is that something that's changed?
Yeah, it's changed. It used to be 50 years, and it's a little bit different. If a corporation owns the copyright, it's even longer than that. I think it's 95 years. So if, let's say, you and I both write a book, and one of us dies and the other one lives another 50 years, mm-hmm. The copyrights goes for 70 years after the death of the last owner of the copyright. So if you and I co-owned it, but I die and you continue living, the copyright goes until you die and then another 70 years.
Okay, so it sort of passes on to one set of heirs in a way.
Right, that's why it's written like that. After that, it goes into the public domain and anybody can use it.
Okay, so like with Mark Twain and Edgar Allan Poe or whatever, I can publish my edition of Huckleberry Finn.
Anybody can now. There's no, those are long since in the public domain.
Now, how much does, just out of curiosity, we're saying it doesn't cost that much. How much does it cost to register copyright?
Well, to register it with just the government yourself. Someone, you go do the work, you find the right form, you figure out how to do it, costs $30. Mm-hmm. Services like ours, I suppose if you just walk into a law office in New York City, it's probably $500.
Okay.
If you use a service like ours, it's including the filing fee, $100.
So the real hardcore do-it-yourselfer can go right to the Copyright Office and do it?
Absolutely.
Okay. You provide, basically, the value-added is...
Yeah, the value-added service at a company.
You're doing it for them.
We do it for them. We tell them exactly how it has to be submitted to the Copyright Office, how many copies, in what format. A lot of that depends on if the work is published or not published. I mean, what we do is we make the process a very simple one. So you don't have to think too hard about, okay, did I fill this in right? Should I have done something else? Should I explain it differently? Mm-hmm. I mean, if that's worth, $67 to you, because that's what we charge, then... Yeah, I mean, it's a smallish amount. I mean, and really, I mean, one of the biggest problems I run into with small publishers and self-publishers in particular is they spend so much time on these little items, and they don't realize they got to spend most of their time on marketing. I mean, that's the one thing they can't buy. They got to go do it themselves, and they've already used up all their energy on this little nitty-gritty stuff. And also, it sounds like a pretty good service that you all offer. Now, how common are like copyright infringements or actionable copyright infringement? I mean, copyright infringement goes on all the time, I guess. I can't tell you the amount of cases that actually make it to court, but if it happens more frequently, certainly in the movie industry. I mean, every once in a while you hear about the guy who submitted a treatment for some kind of a movie, and then they didn't take the treatment, and then all of a sudden it became a movie. Mm-hmm. I mean, you see that. You see some of the, some kind of, there were some big copyright cases. I mean, I'm trying to think back now to when I was in law school that we always would talk about, where there was some music infringement, where somebody took some really identifiable bars of a song and put it in their song, or a few words. Mm-hmm. And there were some suits over that. Of course, there's, copyright infringement and all sorts of software and all that kind of stuff. Yeah, but it doesn't seem to, hit books that. I just don't hear about it. You don't see it very often. And today, what you see a lot is somebody in some country that you couldn't get to, someone steals your work and they're selling it off some server in the Soviet Union, and, you can try to get them shut down. Their ISP will shut them down, but you can't prevent copyright infringement. It's pretty hard to do. So what you have to do is protect yourself the best way that you can. I see someone could buy my book to fine print, and they could send it out to 100 different people, and nobody's ever going to pay me for it. That's copyright infringement. Mm-hmm. But I'm not going to spend any time worrying about it. Well, I think even more common than that. Go to a public library. They got they've got 15 coin-operated copying machines there. Well, the big sign, don't copy copyrighted material. Some libraries and a lot of now the photo mats and those kind of places, they're more nervous, and Kinko's, they may not even make a copy of something that they believe to be copyrighted because they're so afraid of being sued. But, in the world of book publishing, you probably don't see it very often. I don't know of any specific case, and no author I've ever dealt with has had that problem. A lot of people think, boy, my stuff is great, and somebody's going to steal it the minute they see it. But that's not the real world. That's maybe our own narcissistic belief in how good we all are. I had one real world experience back when I had a little publishing company, 30 years ago. And it was a technical rendering that I had in one of the books that we published. And a British publisher picked it up, and I saw it. There it was. I spent like $3,000 on this drawing. And there it was in their book, but it was only on one page of the book. And I was told by the copyright attorney back then, I would say, I don't know whether it's changed now or not, that was one drawing out of a 200-page book, and yes, I could go after him, and yes, maybe I could win, but it wouldn't be worth the money. Well, so that was with a country that's within our copyright conventions and everything. It seemed pretty blatant to me. There's our technical drawing. Well, in a case like that, and it's hard to, without knowing all the facts, and there's too many things to say. Well, yeah, you could probably win, and what it would cost. But yeah, in a case like that where you have a $3,000 drawing, but now if it's all of a sudden appearing in 100,000 books, that's one of the great facets of the U.S. copyright law, is if you could sue them in U.S. federal court, you could go to the judge and say, look, this is a technical rendering. It's obviously mine, and here's the chain of ownership. This is only mine. Nobody else could have had it. These people now have had it in 100,000 books. So, I would like to get statutory damages. Mm-hmm. I don't know if you take one page out of 200 pages, and I don't know how important that one drawing is to the whole scope of the book. But Judge, I'm asking you to say, look, these people were blatantly stole my work, and I want to be compensated, not on my actual damages, but I want to be compensated by the statutory damages.
Mm-hmm.
So I think I should get $500 for every time they sold a book because and maybe I warned them, maybe I sent them a letter and said, this is my copyrighted material, and they kept using it. Those kind of things you always want to do. If you know somebody's in breach of your copyright, you should contact them immediately. You should, because that helps to establish the egregiousness of the other person's behavior.
All right. Well, Mark, it's been real nice talking to you. I'll keep my eye on your books.
Thank you very much.
Take care now. For Publishing Basics Radio, this is Ron Prampshafer. See you next week.